Welcome to the Supreme Court. This morning, two oral summaries of Supreme Court decisions are being given. The first summary is in the case of Secretary of State for Health and another, the Appellants, against Servier Laboratories and others, the Respondents. The appeal concerns the tort of causing loss by unlawful means. This is an economic tort, which consists of acts intended to cause loss to the claimant by interfering with the freedom of a third party in a way which is unlawful and which is intended to cause loss to the claimant. The essential issue on the appeal is whether a necessary element of the unlawful means tort is that the unlawful means should have affected the third party's freedom to deal with the claimant, a dealing requirement. The background to the appeal is that the appellants fund the cost of drugs dispensed by the NHS in England. The respondents developed and manufactured the medicinal product perindopril, which is used in the treatment of cardiovascular diseases. The relevant third parties for the purpose of the claim are the European Patent Office, EPO, and the English courts. In 2004, the respondents were granted a patent from the EPO in respect of a form of the salt of perindopril, and later defended and sought to enforce the UK designation of patent in proceedings before the English courts. In July 2005, the High Court held that the patent was invalid, as it lacked novelty, or alternatively was obvious over another existing patent. Subsequently, the EPO revoked the patent. The appellants allege that in obtaining, defending, and enforcing the patent, Servier, the third respondent, practiced deceit on the EPO and or the courts, with the intention of profiting at the expense of the appellants. In particular, it is alleged representations were made as to the novelty and or lack of obviousness of the product that Servier knew to be false, or that were made with reckless indifference as to their truth. As a result of the alleged deceit, the appellants contend that manufacturers of generic perindopril did not enter the market as early as it otherwise would have done. This would have driven down the price of perindopril and meant that the appellants had to pay higher prices. This alleged conduct is said to form the basis of an unlawful means tort claim, in which damages and interest in excess of £200 million are sought. The appellant's claim was struck out by the courts below, who held that the majority of the House of Lords, in their decision in OBG Limited and Allen in 2008, decided that the dealing requirement was a necessary element of the unlawful means tort, that they were bound by that decision, and that, as was common ground, the dealing requirement was not satisfied in this case. The appellants now appealed to the Supreme Court, contending that the dealing requirement should not be treated as forming part of the ratio of OBG, and thus the courts below were wrong to consider themselves bound by it, issue 1. Alternatively, they argue that the Supreme Court should depart from OBG and dispense with the dealing requirement, issue 2. In its judgment, the Supreme Court unanimously dismisses the appeal. Lord Hanman delivers the lead judgment, Lord Sales gives a short concurring judgment. The reasons for the judgment. Issue 1. Is the dealing requirement part of the ratio of OBG? The Supreme Court agrees with the conclusions of the courts below that the dealing requirement is part of the ratio of OBG. It observes that the general context of the decision is that it was seen by the House of Lords as an opportunity to clarify and to give coherent shape to the law of economic torts, and that in carrying out this task, a central concern for the majority was to keep the tort within reasonable bounds. This was partly to reduce the scope of the tort, but also to reflect the policy consideration. This is an area of economic activity, the regulation of which should largely be left to Parliament. More specifically, that the dealing requirement is part of the ratio of OBG is consistent with 1. The explanation given in the leading speech of Lord Hoffman of the rationale of the unlawful means tort, which is to preserve a person's liberty to deal with others. 2. Lord Hoffman's definition of the essential elements of the tort. 3. Lord Hoffman's explanation and justification of the dealing requirement through an analysis of key authorities focusing on whether or not there is dealing. 4, the authorities in which liability for the unlawful means tort has been established, which all involve dealings. 5, the concern that the tort be kept within reasonable bounds. 6, the fact that the other members of the majority understood Lord Hoffman's definition of the tort to include a dealing requirement and endorsed it on that basis. And 7, the fact that OBG has been understood to impose a dealing requirement by the courts both in this country and elsewhere in the Commonwealth, such as New Zealand, Singapore, Australia, and Canada. Issue 2. Should OBG be departed from? The appellants contend that the dealing requirement is an undesirable and unnecessary addition to the essential elements of the unlawful means tort. The appellants advance 3 alternative approaches as to how the tort could be refashioned. A fundamental difficulty for the appellants is that they need to show that this is an appropriate case for the Supreme Court to depart from OBG in accordance with the 1996 practice statement. Whilst the appellants can point to some academic criticism of the decisions in OBG, they've not provided any real-life examples of it causing difficulties, creating uncertainty, or impeding the development of the law. As to their proposed alternatives, the appellants have not shown that these formulations of the tort offer a safe and appropriate way of developing the law. The appellant's first alternative involves leaving the law as stated in OBG, but without a dealing requirement, thereby dispensing with the control mechanism which the House of Lords considered to be both necessary and desirable. The dealing requirement performs the valuable function of delineating the degree of connection which is required between the unlawful means used and the damage suffered. This is particularly important where a tort permits recovery for pure economic loss and by persons other than the immediate victim of the wrongful act. The dealing requirement also minimises the danger of there being indeterminate liability to a wide range of claimants. The second alternative involves adapting in part the alternative formulation of the unlawful means tort proposed by Lord Sales and Professor Davis in their 2018 Law Quarterly Review article. But this is incoherent and unsustainable, as the reformulation ought to be considered in its entirety, not on a pick and choose basis. The appellant's third alternative, which is based on a decision of the Canadian Supreme Court, is a more extreme version of the appellant's first alternative and must equally be rejected. The appeal is accordingly dismissed.